Welcome. Today, we're going over the Courtney Clenney status hearing in Miami-Dade County, Florida, in the courtroom of Andrea Wolfson. Attending is Prosecutor Abuhoff and Defense Attorney John Prieto, and Courtney Clenney is also in attendance. There's quite a few motions outstanding. Let's begin and see what the judge is going to do as far as dates to get everything taken care of.
No, Ms. Gloss is not officially on this case. She was on the computer case for the Prost.
Yeah, okay, very good. All right, we're here now to address the state of Florida versus Courtney Clenney. Noted President Assistant State Abuhoff and Attorney Prieto, as well as Clenney, who is present in court. And I'll turn it over to the defense.
Sure, Judge. Just to kind of update the court, we have pending a motion to dismiss. We have pending a motion for reconsideration of bond, which we filed a second amended motion recently. We have a motion for bill of particulars, that's count 2 of the information. We have a motion to suppress surreptitious recordings. We have a motion to compel 404 evidence. And we have a motion to limit concerning the CGI that we're working on. As of this morning, the only one that has been responded to in writing, which was last night at, I think, so roughly 7 p.m., was a response by the state, which I have not reviewed, the motion to dismiss. All other motions have not been responded to in writing at all, and my communication attempts with the state have fell on deaf ears until yesterday. I had not heard from them in probably about 30 days, despite repeated emails. I know Mr. Abuhoff was definitely the case and then out. I do understand that, and out for the holidays. But we need some hard dates for them to respond. Again, I know it appears Mr. Abuhoff may be in trial on Monday, depending on what the defendant ultimately decides, but you know, as we used to be called, fungible to a certain extent. You know, there's multiple state attorneys that are on this case, and we need to get it moving. And again, you know, we've been asking for over 60 days. This is not subject to a motion, but we've been asking for over 60 days, and it's gone unresponded to. If they can just please have their big wit update the addresses of all the civilian witnesses to make sure.
Not unreasonable.
You know,
that should be done.
Moving forward and serving them for depositions, that we're not chasing, you know, squirrels running around the country. Mm-hmm. So again, Mr. Abuhoff, last night in his very professional response, indicated that he's aware that these things need to get responded to, and he's doing, I guess, his best efforts to make that happen. But at this point, we're asking for some hard dates for the state to reply, and especially here in Dade, I think the most paramount one in the defense's mind is the motion for reconsideration of bond. So I would ask, I'm asking for dates, response dates for all of these, but I would put that one in the forefront for him to have a sufficient amount of time to respond in writing and to set a hearing on that.
Okay. Is that it before I turn it over to the state?
I
mean, I
can't read my own handwriting,
yeah.
But let me get these out. Yeah, but I mean, that's where we're at.
Okay, so one thing I want to ask for, you just respond in whatever way you wish, is I would love to take the easier things first. To me, one of the easiest things Mr. Prieto mentioned was the addresses of the witnesses.
Yes, Judge.
The status of that.
So, Judge, I can tell you that the most that they've done is to try and make telephonic contact with them.
They being the victim witness.
My victim witness counselors. So, and I apologize because we need to do more than just that, obviously. So I made a note for myself, as soon as I go back today, that's the first thing I'm gonna tell them to do, is confirm everybody's address one way or the other. Just so that I can get that to them hopefully by Monday.
Well, and I'm gonna put a deadline on that for the next Friday. So by next Friday, the 12th, all listed witnesses, now certainly I know that discovery tends to be an evolving process, so if something new arises, then this wouldn't be applicable, but any witnesses who are already on the witness list, you must provide updated addresses to the defense by Friday, the 12th.
Yes, Judge.
At 5 p.m. Now, do you intend to file responses in writing to the other defense motions other than the motions to dismiss that you already filed?
Yes, Judge. So and not in any particular order, but I have I guess a request or a question for the defense. One of their motions is to admit a CGI video. I have not seen this video. I'm not sure if it's been created yet. It's hard for me to object to it or even have an opinion on it if I don't know what it is.
Okay, that's fair, Mr. Prieto.
Sure, Judge, it's a kind of a preliminary motion.
This is the video that recreates the event according to the defense's representation of it, Courtney Clenney's version of what happened, a CGI video that would lay it all out for the jury in a visual
with regard to the admissibility
of how she said everything happened.
Demonstrative aid versus evidence. It's not, obviously it's evidence based, but it's
Your
very
intention would be for it to be a demonstrative.
correct.
Yeah, okay.
Right, yeah, there's changes in how the law applies. I don't think it's admissible,
Yeah.
but it's definitely demonstrative. So it's kind of a pretrial, that's why we named it a motion limiting. We don't have a video. It's not complete. They've been working on it. But we just, before we go ahead and finalize the video, and obviously that's, the court's ruling on this pending motion limiting could change depending on, obviously, the expert witness testimony that would be presented. But we want to have kind of a direction before we go through the expenses of finalizing the actual video itself.
So I guess what I would want to have happen is if
I'm sorry about all the background noise. Not much I can do with coming right from the court feed. The clerk is right there on the mic. And he's very, very busy.
Company, I'm sorry.
yeah, no, that's what I would need to say, okay, what do we even air in front of you?
The company is 3D Forensics.
I really
They
don't
have a
understand why the clerk's still
100%,
being
admissibility rate as far as being able to show they've never been denied. And we
Either
have seen
that or it's
what
just
they've
being
done
picked up by
and
the
their
judge's mic,
the
but
resume of the
it's
engineers that
pretty
developed this technology and whatnot. So yes, we have all of that we can provide.
I think that would be okay.
Certainly helpful, Judge, but, the hard part about it is if this comes down, especially for demonstrative purposes, a decision by the court. And it'll come down to the prejudicial effect of what this video actually shows. So,
So in general terms, if you provided an example of something that had been used in a similar litigation, which I'm sure, you didn't just come up with this out of thin air, obviously this exists, right? So I would need to see that type of an example, then I think you would have to explain to both Mr. Abuhoff and the court how you see and envision that playing out in reference to Ms. Clenney's case.
Sure.
That way then I could rule on a legal matter, say, okay, so yes, no, or a different
Right.
route, and then create the actual video for a final ruling at some point.
Right, absolutely. I think it's going to be subject to final ruling testimony by the experts as far as how the court's going to rule on that. But yeah, Judge, they've done everything from civil litigation, reenactment, vehicle collisions for personal injury cases to active police shootings. It's all based on video and then being able to get measurable points of reference, and then they do their fancy engineering stuff to it.
Which
But
is what the Bravo is, right, the fancy engineering.
well, what this is, which is why this is, well, it's not different, but they used the raw data from the Faro scans that were done at the apartment to produce the scene.
Got it.
So that part clearly is, it can't be contested.
I'm sorry, I didn't speak over you.
That's,
We're way far ahead of ourselves at this point.
sure.
I think that I won't require necessarily the state to file a response unless we were able to provide some sort of examples of how this would play out. So that one,
We can
that to
table
me
that.
is, yeah, that's way
Yes.
in this, not distant future, but in the future.
Yes.
What about the motion for reconsideration of bond, which I agree with Mr. Prieto would probably be something we could do as a threshold matter? Are you going to file a response?
I am, Judge. That's the next one I'm going to work on. So this is a third request of the defense for a bond. First, was the Arthur hearing, then there was another hearing for reconsideration based off of a medical examiner listed as well as a knife-throwing expert. And now there is a secondary witness, which has not been listed yet, is the grounds for this one. So the only issue with my response is they have provided this person's report. I don't know if they.
You'll
intend
need to
list
check
the
out
person or
my
intend to
video
actually use
on
them,
this actual
but
motion because he's leaving out
I do
all
need
the
to
claims of
publish them.
prosecutorial
it's hard to say
misconduct.
outside
They're
of
not
just
really
writing
not
off
releasing
their report,
information about certain evidence of
what
statements
it
made
is
by
that I would
neighbors
respond to.
and also the delays that they have
Yeah,
caused.
Judge, I don't
You're
see
just
why
skipping
the
right
state
over
needs
it.
to depose this expert witness. It's an expert medical examiner from Hillsborough County that in the collateral civil case testified to matters pertinent to basic arguments that were made at the Arthur hearing by the state. The state argued at the Arthur hearing, quite honestly, and it wasn't Mr. Abuhoff, but a timeline where in the state's mind, right, as charging this as a manslaughter, the depraved mind, charges a second, right? The depraved mind aspect of which was the third element of what the state has to prove for manslaughter. They claimed that Ms. Clenney allowed the alleged victim in this case to bleed out basically 13 to 14 minutes prior to calling 911. This expert, the defense's argument was no, she called 911 right away. The phone records show, right, that she called 911 at this, anyway, I'm getting into the minutiae.
Is there a transcript of the testimony that this witness gave at a prior proceeding?
There is in the
Yep.
collateral civil matter, there
This is
absolutely is.
very
Is that something
important point.
provided to the state?
Manslaughter is a bondable
It
offense.
cost me an arm and a leg, but sure, I could
If they
order
overcharge,
deposition.
this could be the
I
win.
mean, you
to
know,
get her
I think
bond.
At some point in the future, they're going to want to depose this person, but if you're relying on, and I'm not saying that it has to happen before the motion for reconsideration, fine, don't get me wrong, but what I'm saying is, in order for the state to be able to respond, because that is one of the bases that you have put forth, then he needs to know what this person is going to say.
Right, I attached a very detailed expert report as an exhibit to the motion where Dr. Webb's, Malad Webb, details his findings, the basis of his findings. He refers to all the sources that he used to find it. All those opinions are contained in that expert report.
Okay,
So that's been provided to the state.
all right. How long do you need to file a response?
So again, Judge, so it depends on this trial. If this trial goes on Monday, I anticipate the trial will be finished Thursday or Friday. We have a probation hearing that I don't think is going to go on Friday. It should flee out. So in theory, I can start working on this either Friday or the following Monday.
Okay.
But I need to depose him. If I am providing
Danny
this
has the
deposition,
same
I don't
expression on her
depose him. I
face
know what he's going
every
to
hearing.
testify to. So the problem is the report is going to be a summary of what this person
Very
believes.
quiet,
I'm not gonna-
paying attention, but those seem to be quite,
And Judge, I did speak to Mr. Abuhoff.
tired of the routine, so to speak.
Obviously, look at yourself.
Tired
This medical examiner determines, based on his review of,
and frustrated at the delays.
I believe qualifies as an expert, but he says that the injury occurred more likely than not to his degree of medical certainty that Ms. Clenney called 911 immediately after.
Let me ask you this, Mr. Prieto. When you talk about the fact that you want to prioritize the motion for reconsideration bond, which I agree, is that something that you are asking this board to do before we take a 2-week break during the holidays? In other words, does that have to happen before the 19th of December, or could it happen the week of January 5th?
Judge, I have to defer to the court and, you know, Mr. Abuhoff is entitled to respond, so I'll defer to the court and the state on this. I mean, but obviously, there's a long history here of delay for a lot of reasons.
Just
And
talking for scheduling purposes, because you know.
I will make myself available
Okay,
on the earliest date possible.
okay, exactly.
If we can set it for the 19th, Judge. The 18th.
I have literally said everything in this division for the 19th, and we're also supposed to host a little gathering for the staff after calendar. So why don't we do the 18th?
Okay.
I want your response done by the 16th at 5 p.m. And we will set the motion for reconsideration on 12/18. We'll just take a look and make sure that's not going to be problematic.
So we will have another hearing on December 18th in regards to this issue.
What about the motion for bill of particulars? Does the state
Judge.
have a response on that?
By that 16th,
Okay, everything.
well, the 16th, that one will be either handled or responded to.
Okay, bill of particulars by 12/16 at 5 p.m. All right, and the motion to suppress.
So Judge, this was previously litigated before the Arthur hearing, specifically only through the Arthur hearing. There was motions filed by the defense, the motion filed by the state. The defense's motion is very similar. I don't think it contains too many differences. I do intend to respond to it, but based off of the items that I think are taking precedent, I would ask that this be rolled over to the new year, and I'd be allowed to respond by maybe that first week of January.
I have no problem with that, Judge. I would just alert the state that this is an amended motion to suppress. We previously withdrew the motion to suppress simply because, although it's filed under a different rule of procedure, anyway, long story short is we amended it to specify the exact files as were provided to us in discovery that we're seeking to suppress so that they have them. And I would just urge this prosecutor, because his prior colleague filed a response, made certain arguments. I would just ask this prosecutor to review those and see if he wants to adopt those as his response.
I'm sure he will. So the motion is to suppress response will be due by January 9th at 5 p.m. And what about the 404?
So I intend, honestly, we got a lot
Prior
of it together for
incidences,
the Arthur hearing.
Again, you know,
There was one
behavior and
incident we
character.
were made aware of that occurred in Colorado. After the fact, we became aware of it. So it's going to take me not too much time to be able to put that together. The more important thing, though, Judge, is I don't want to list these incidents without actually having witnesses that will be available, or I know I'll be able to produce. So that's the amount of time I'm going to need. It's going to be more so collecting those witnesses. So I would request probably the middle of January for that.
Any objections?
right there is one of the reasons
I would
we
just
see
ask
differences
the
in evidence
Mr.
presented in
President,
court and
because
what we actually see out here
The designation.
in the public as far as
really
incidents that
impacts
happen. There may be
the
about that
manner in
Colorado
which we take your
hearing
depositions.
going on,
So
or
now this is going to push.
but if there are no
these 404
witnesses, if there's nobody to
witnesses.
bring in, it doesn't get in.
It's 448, but
And we'll all know about it, and we'll
it's
have
going to
it
now push
about
us
it,
into February.
but it won't get to the jury.
So I understand the state needs to research it. If they are relying on specific incidents, they need to gather police reports. If there are police reports, I think they're required to disclose that to us. So I know they got some meat on the bone there, but I would just ask that they make, that's a hard deadline.
January 16th, 5 p.m.
And that's the witnesses, designating the witnesses plus any documentary evidence that they're required to provide under the rules.
Mhm. Things are moving forward finally. We are getting closer. Of course, by now I don't have to tell you that there'll be no trial in 2025, right? We've got hearings through the first quarter.
Right.
Anything further from the state at this time?
Just to confirm, Judge, we want to litigate that motion to dismiss on that date as well? Or I'm not sure if defense wants to file a response.
Prieto wanted to prioritize the reconsideration of bond, but that's fine with me if everyone would be ready to do that on the 18th.
Wow, those are two big motions on the same day.
Was there a, they've already responded, so I need to review that. Do you think the court
There's no rush on it.
would have enough time on the 18th to do that? I don't want to cram the court's calendar, because we can set that off in early January as well. Or the 18th, I mean, I'll be ready. I think the state's ready, we'll be ready,
No, what are we talking about? Allowed?
I think, at the most.
Well, Judge, the better question is going to be whether or not an evidentiary hearing is needed. I think
Right.
it's just argument. So I think, especially for
Do
the,
that, let's keep on plan on the 18th,
Okay,
and then obviously you might get a ruling on the dismissal part, but
right, I understand. And as far as evidentiary wise, there's already record evidence in the collateral proceeding that is sworn to testimony, and that was provided to the state.
I'm going to provide a copy to the court.
Yeah, no, I'll put together a binder for the judge, but yeah, I think that's right, and I don't, if I foresee some type of other live testimony being needed, we'll let everyone know.
anything further, Mr. Adams?
No, Judge.
I think that's it, Judge.
Very good, I have a meeting that I need to
Yep,
get.
absolutely.
Thank you all.
You got it, Judge.
Very
Take care.
good. We're in recess.
All right. So there it is. And Dawn, and that was quite the hearing. We at least know that the motion to readdress bond will be heard on December 18th. And so hopefully we'll be able to get you inside the courtroom from that one also. But if not, I will at least give you an update on what happens. Well, please check out below. I have linked. I broke down that actual amended readdressment of the bond issue on a separate video. And I really think you should check it out because, wow, that prosecutor just glazed over most of what was in there. And I can't wait to read his response when it comes through, if we can get our hands on it. And I'm really looking forward to this hearing on December 18th. But it does look like things are moving forward, finally. Things are getting addressed and dates are being set, firm dates are being set. And we've got quite a few hearings through December and January. And well, we'll see about a trial date. I don't know what's going to go through, but they're also going to be addressing the motion to dismiss in early January. Things are changing a little bit in the Courtney Clenney case. So we're on top of it. We're all looking into everything that we can out of Miami-Dade County in Florida. Thank you for joining me. And like I said, don't forget to comment if you've got anything. I'd like to know what you think about the prosecutor not actually responding to most of these motions that have been filed since like September and forward. Granted, this one about bail was just filed on December 3rd. However, there's plenty out there that they are just not responding to. 60 days with no response in regards to witnesses. I mean, yeah, they're kind of adding to some of the complaints that the defense has had in their request for bond. So check it out. Link will be below. Like, share, and comment if you like the comment. If you like the content, subscribe so you get notification for when I'll be dropping the next one. And on that, have a great day.